This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
No, couldn't be better. As we're taping this, we've reached the finish line, as I like to say, on a Friday afternoon. And although we miss our fearless leader, Ace, who's, by the way, where is he tonight?
Undisclosed location. He I think is taking a long weekend. So I hope he's somewhere having fun.
And I think Monday is a court holiday, isn't it? Or is it next week?
I'm not sure. Peeling back the curtain a little bit for those who are interested in the Adam Carolla-verse, we don't really observe those, so I've stopped caring about them.
I love it. I won't refer you to any employment lawyers, so stay away from that. I think we got to start, interestingly at least, with one thing that I think we'll dive into on Sunday, along with Murdaugh, the Rust case and Alec Baldwin. One of the interesting things is and I'll get the name of the New Mexico lawyer who identified this issue. She issue spotted, I think it was a she, issue spotted that the part of the charging document, which is alleging a mandatory prison term, was enacted a number of months after the incident.
Yeah, her name is Caitlin Smith, and she was the first one to identify it while speaking on another legal podcast. Yeah, that's it's very interesting, and this is a
great issue. Great issue. The law, I think, is fairly clear. You could have an offense or charge that took place prior to the enactment. You just can't criminalize it after the fact. That's the definition of ex post facto. So that's going to be, the prosecutor says they're looking at it now. I don't know why they didn't look at it before, because one of the first things you do when you charge is you find the count, basically, and then you do a search to see how that count has been interpreted. Well, if you're looking at the charge that you're going to file and it says enacted such and such a date, and that date postdates the date of the offense, that's a pretty big red flag. And so that'll be interesting. And if the prosecutor doesn't stand up and dismiss, then they'll be able to do what's called a demur. And basically that says, even if everything you say is true, you cannot, as a legal matter, proceed on the count that was not criminal until after the fact. So that's interesting. And speaking of interesting, we'll now go to Murdaugh,
real fast, I want to highlight one more thing in the Rust case that I've been following that I think is somewhat interesting, and that is the special prosecutor who was appointed, Andrea Reeb, who was appointed to this case, a number of months back, and has since gotten into the House of Representatives in New Mexico as a Republican. And now I believe that Alec Baldwin's legal team is challenging the fact that she is now basically serving two masters and serving in two separate forms, two separate arms of the government, which is not permissible. So that'll be interesting.
Yeah, what's interesting, in California, there's a quirk in our Constitution. If you're in the legislature, and by the way, if you're in the legislature in California, you can practice law. So there's not a number, because the legislature in California no longer has as many lawyers as it traditionally did. But there's also a provision where you can basically continue your cases or your clients' cases when the legislature is in session. So some kind of cynics have accused various clients of hiring lawyers in the past who were legislators in order to get their case continued. So just a little fun fact, and I'll take a look before Sunday as to whether there's a similar fact in Arizona. But if it were California, it's interesting as to whether a sitting prosecutor could also be in the state legislature. I don't think there's any prohibition, but see if Arizona there is.
Yeah, New Mexico, but
good
yes.
New Mexico, good issue spot there. Arizona is because I'm thinking Super Bowls.
Yeah, absolutely. Aren't we all? Well, yeah, I agree. Sorry, I just wanted to get that in there, but let's also move over to Murdaugh, as you said. There's been a lot going on. I got to be honest, I'm very fortunate that I don't have this ability, but if I had the time, I believe I would be watching this case all day, every day. It's so interesting. And there's so many.
One of the great things about it is you get evidentiary rulings because of the way the judge is handling this. And this is not a criticism at all. It's just an observation. He's doing the evidentiary hearings, or what you would traditionally call a motion in limine, at the same time the trial is going on. What he's doing, though, is he's sending the jury out, and then he's hearing either evidence, proffers, or whatever else outside the presence of the jury and making decisions in real time, which obviously sparks fireworks on Twitter, as you would expect. Sure. And people taking sides. He made a good decision. He didn't make a good decision. One of the things that I like, if you could, is a takeaway from this, is I've always had, and I know this is kind of a classical throwback, I've always had a real problem with what are called speaking objections. And this judge has the same little quirk as I do, and as a lot of people do from our area or our vintage. A speaking objection, I always say, is either coaching the witness by saying, Judge, I object to this because A, B, C, or D. You might think that what you're doing is educating the judge or telling your point. No, what you're doing is, the argument is that you're coaching the witness. You're letting the witness know what it is, and by speaking and giving a speech, so to speak, that is coaching. What you're supposed to do traditionally is just say the grounds. So if you say objection, asked and answered. Objection, non-responsive, motion to strike. Objection, leading. That is what you're supposed to do. That is what is taught. This judge is holding them to it, and more power to him.
Yeah, I mean, I think that's very smart, because if I was a witness and I heard an objection with a speech, I would be thinking about how I should modify my answer to try to, it's just, that's kind of inherent.
Right, and it doesn't necessarily mean that you're trying to do something untoward. No. It's just a matter of how your brain operates.
Yeah, that's just the way I work as a human. So yeah, that would totally make sense.
So they put on, there was one witness today or yesterday, Satterfield, who was, some people were saying great witness. He feels sorry for him. He's a victim. Don't disagree. And powerful. Yeah, I mean, because you can't watch the witness and not feel empathy for anybody who's victimized. However, was that something that leads the jury closer to evidence that in support of a conviction for murder? I don't see it. The witness was talking about events that predated the murder, that if you believe the witness, and there's no reason not to, he wasn't on notice prior to the murder of anything untoward going on. And this is a problem, I think. I mean, I've complimented the judge. I'll give him a little pushback here. I don't understand why this witness was allowed to testify. It does not in any way, shape, or form go, I think, to the defendant's state of mind, namely Murdaugh, because there wasn't anything to indicate that this person, Satterfield, had any indication that the jig was up, so to speak. So I don't get it. That doesn't push me. Today they ended, they didn't actually end, but they put on a witness for phones, Gary. I don't know if you saw this.
I did, yeah. There was a phone expert.
I like to, we'll take a little victory lap. Yeah, we'll take a little victory lap because we predicted this was going to make people's eyes gloss over. And I think if not only do I suspect and based on 40 years have a pretty good indication of how it was taken by the jury, but people were just, commenting, I don't get it. I don't understand what was the point. And it's exactly what I talk about with these phones, because you get up there, the prosecution thinks it ties a bunch of stuff together. All it inevitably does is on cross, I think it undermines their case and shows and deflects from what a prosecution narrative should be.
Yeah, absolutely. I couldn't agree more. I don't know if you saw this tweet, Mark. I'm shifting gears a little bit, going back to something that we talked about. We saw a video in one of our recent episodes of an expert testifying about the guns, and he was talking about how he had test fired the assault weapon, not the shotgun that was used. And what I was informed on by a fan on Twitter was that apparently that 300 blackout round is designed so that if it is not shot through a suppressor, then that is the way you would expect the gun to perform. So I thought that was interesting because it's possible that they were not using a suppressor when test firing the weapon, in which case that's somewhat misleading testimony because, that is how you would expect that gun to perform. But that expert was able to let the prosecutor lead him into saying that the gun was malfunctioning, which it sounds like maybe it was not. It's functioning properly. It just wasn't being tested in the same manner that it would normally be used.
So it'll be interesting to see whether or not they recall that person, and now that if in fact they didn't know it at the time, but they know it now, or they call their own ballistics expert who then kind of lays out that ballistics expert. One of the other things about the ballistics that I was taking a look at, because it had also was kind of peculiar to me. If I'm not mistaken, the ballistic trajectory appeared that there's a suggestion that whoever was shooting was crouching. I don't know if you saw that, but if that's the case, that's an interesting fact, which I think you hear about in closing.
Yeah, absolutely. Anyways, there was a clip that we have here of Dick getting a little bit animated. Do you want to check that out?
Yeah, please. Let's wrap up with that.
All right, here we go.
I objected to a conversation. We're aware of that conversation, but I objected knowing where he was going, which was, and in that same interview, by the way, that she gave about a statement where Maggie said that she was concerned about money, she also indicated Maggie was never concerned about money. Either way, it's hearsay. He said before Your Honor ruled, was she concerned about money or wasn't she concerned about money? He testified, which is to hearsay. I would move for mistrial. I think that's unduly prejudicial based on the last 3 weeks we've heard of financial misconduct on part of the defendant. I would move for mistrial. I would move that it's not mistrial because I don't think, even if you give this jury an instruction, you can't unring the bell. You can't correct that. And now I've had to draw attention to it, even more so by objecting to it. He knew that was wrong. Thank you, Your Honor.
Mr. Meadows.
Your Honor, and for the record, I apologize for that question. I don't have to say it.
We're not here about apologies. Go ahead.
And I can't help it.
Yes.
I like this judge. I like his attitude.
I don't want to hear about your apologies. You obviously committed misconduct. You did it on purpose. Why are you doing it?
I like this judge. I like his attitude. And I got to say, Dick sounded a lot like things I've heard you say in the past, where it's like, yeah, you give them an instruction all you want, but 12 people just heard that. And whether or not they are instructed, it's, again, goes to human nature that you can't just eliminate that from your mind.
It's why I named the book Mistrial, and why I think I've had an inordinate amount of mistrials in my career, because you can't do, especially if you're the prosecutor. Remember, there is a fundamental difference between the defense and the prosecution. The defense is there to zealously defend. That's your duty. Your duty is zealously defend within the ethical bounds. Prosecutor does not have that. That win at any cost, ethical cost, that is not what the prosecutor is supposed to do. The prosecutor can strike hard blows, to paraphrase the old quote, but you're supposed to seek truth, justice, and justice does not mean asking questions. My father used to joke, I invoke him all the time, that he says the mark of a good trial lawyer is when you commit misconduct and know you're doing it. Well, that prosecutor right there, he committed misconduct and he knew he was doing it. So
but he's very sorry. He's very sorry.
Very sorry. I'm sorry. But I'm here to win. The thing about prosecutors are, if they get the win, they get the glory. And nobody's around to deal with the reversal later on, because that's years later. The prosecutor's gone on to be a judge or gone into private practice and is making a fortune.
Yeah, absolutely. Well, Mark, as you alluded to, we're going to get up early and knock out an episode before we all settle in to our couches and enjoy the Super Bowl. But until then, thank you very much for making some time at the finish line, as you said. I
love it, Gary. It's good to see you. We might do a little talk about the class action filed against the NFL on Sunday. Remind me, and I'll bone up on that.
That would be only appropriate. Mark, thanks again for your time, and we'll see you on Sunday. Bye-bye.
Bye-bye.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.